Okay, so this is the actual law in respect of the flexible working arrangement. So subject to part 12 or anything contained in the contract of service, an employee may apply to an employer for a flexible working arrangement to vary the hours of work, days of work, or place of work in relation to his employment. By reading at the section subject to part 12 or anything contained in the contract of service, so the law actually provides some leeway to the employer to actually consider the application for the flexible working arrangement, because the application for flexible working arrangement must be subjected to the terms of the contract of service. So mainly it depends on the nature of the business of the employer, whether to allow or to reject the flexible working arrangement. So let me go back to the slide. Okay, so there's amendment at section 37 as well in respect of the maternity leave. So maternity leave is now increased from 60 days to 98 days. And in order for the maternity allowance to be payable, there are certain conditions to be fulfilled in order to be paid with the maternity allowance. The female employee has been employed not less than 90 days during 9 months immediately before confinement, and employed by the employer at any time in the 4 months immediately before her confinement, and must be less than 5 surviving children. So if you have 5 children, then you are not entitled. So the maximum is 4. So I think the line must be drawn between maternity leave and maternity allowance. Both are different things actually. So if you are entitled to maternity leave, meaning that the employer cannot terminate the female employee during the 98 days. However, it doesn't mean that they are entitled to the maternity allowance. If they fulfill the certain condition, as I just mentioned, then they are entitled to both maternity allowance and maternity leave. So there is this introduction of section 60 capital FA in respect of the paternity leave. Married male employees are given 7 days of paternity leave, subject to a maximum of 5 confinements, provided that at least 12 months of employment by the same employer, and informing employer of the pregnancy at least 30 days from the expected confinement. So if you get twin or triplet, you only get 1 confinement for 2 or 3 kids. So not really worth it. So okay, the next amendment is the introduction of section 18 capital A in respect of the calculation for the wages for incomplete month. So where an employee has not completed a whole month of service due to any of the following reason, then there is the formula. So I think I will leave it this calculation to Agnes or Marcus. Yeah. So if any question came across in respect of this topic, please lend me a hand. I'm not good in calculation. So
yeah. Ladies and gentlemen, sorry, I just interrupt
yeah,
a bit.
no problem. Yes.
Some of your calculation questions, Marcus is already at the same time replying in the chat room for you. Yeah. So but then I do also hope that while you're posting the question, while looking at the reply, also pay attention to Jerry. Jerry has super important information. Jerry,
Yeah,
over to you. Sorry for interrupting.
Thank you. No problem. No problem.
Yeah.
Thank you.
Marcus, you continue the answering the question on those numbers.
Okay. So there's this amendment as well in respect of the employment of foreign employee. So there is a substitution of sections 60 capital K. So previously, an employer was only required to furnish the particulars of the foreign workers to the Director General. We call it DG. So now prior approval from the DG must be obtained before employing any foreign employee. So there are certain conditions which the DG may consider. So as long as there is no outstanding matter relating to any order under the Act, or any case relating to any conviction of any offense under the Employment Act, or has not been convicted for any offense in relation to anti-trafficking in person and forced labor, the DG may approve the application for employing the foreign worker. So please remember, if you have foreign employee, you must get prior approval from the DG. So there's amendment at section 33A in respect of the contractor for labor. So those who supplying labor. Previously, the Act only required the contractor for labor to be registered with DG prior to the supply of employee to the principal contractor or subcontractor, and to maintain registers containing information of each employee that it supplies. But now a contractor for labor is required to enter into a written contract that is available for inspection. The intention of this law is to promote transparency and also to avoid exploitations of labor. So the next amendment is the introduction of sections 101 capital C, the presumption of employer and employee relationship. So if this is quite interesting topic to talk about. A person, unless proven otherwise, is presumed as an employee, where his manner of work is subject to the control or direction of another person, be his hours of work are subject to the control of another person. We call it control test. So where is provided with tools, material, or equipment by another person to execute work. Actually, I don't really get it. Why there's this subsection C? It doesn't really make sense. If someone is provided with tools, material, or equipment, why this employee, why this person can be considered as an employee? Actually, it doesn't really signify anything, but the law states so, so we have no choice. We have to comply. And D, subsection D, where his work constitute an integral part of another person's business. D, E, where his work is performed solely for the benefit of another person, or where payment is made to him in return for work done by him at regular intervals.
10点半哦，你。
Sorry. Oh, and
sorry, it's okay. I've just
no,
muted them.
yeah, and such payment constitutes the majority of his payment. So if anyone fall under all these or one of these circumstances, he or she can be considered, is presumed as an employee. Why there is such introduction of section 101C? Because there are too many what I can call it, there are too many abuse by the companies. Sometimes the companies will ask the employee to sign a contract of contract for service, and this is different with contract of service. They are two different things. So the benefit of contract for service, they are not subjected to the Employment Act. Then the termination of a contractor is far more easy than an employee. So that's why there's this introduction of section 101 capital C, because the government does not want the companies to abuse the status of contractor. So there's this new introductions of section 69F in respect of the prohibition of discrimination. So now DG has the power, Director General has the power to inquire into any dispute between the employee and the employer in regards to any matter relating to discrimination in employment, DG may make an order. So if you fail to comply with the DG order, the fine is not exceeding 50,000. So they can fine up to 50,000. So if continuing offense, daily fine not exceeding 1K for each day, the offense continues until the conviction. But the law doesn't define what is discrimination. So we can't really know what the law define, what types of action constitute discrimination. So, and the law is new, there is no precedent on this. So I believe that soon as there will be some case law saying describing what is discrimination. So I will update you all if I came across this. So so there is an introduction of section 81 capital H as well on the notice of sexual harassment. So now the employee shall exhibit a notice in raising awareness on sexual harassment. So the purpose of this law is to raise awareness at the workplace, to maintain conduct and ethics in the workplace, and not to engage in any form of action that could lead to sexual harassment. I actually have a sample of the notice. If any one of you are interested, could email me. I will put my email at the end of my slide. So I will send you over the notice, the template. So this is the procedure for the sexual harassment complaint. So it is stipulated under section 81B. So I do not wish to go into it. So this is the procedure, and this is not a new amendment actually. So it's very easy to understand. So under section 81D, any one of you can just bring me up and I can explain personally to you. So this is an offense. Offense is stated under the section 81 capital A. So any employer who fail to inquire into complaint of sexual harassment, to inform the complainant of the refusal and the reason for the refusal as required under subsection 81 capital B, to inquire into the complaints of sexual harassment when directed to do so, fail to submit a report into inquiry, a report of inquiry into sexual harassment to the DG, then the employer commits an offense and shall on conviction be liable to a fine not exceeding 50,000 ringgit. So guys, don't take it lightly on any complaint relating to sexual harassment. Please just be serious on sexual harassment, and don't take it lightly, because there is a penalty imposed if you ignore the complaint of the sexual harassment. So this is the general penalty. There's an amendment under section 99 capital A. So there's an increment of the penalty from 10K to 50K for those who commit any offense under the Employment Act, for those who did not comply with the act. So this is a harsher punishment to ensure compliance. So I have finished the key amendments to the Employment Act. So Agnes, can I continue with the key amendment to the Industrial Act, or would you like to add anything?